In my intro, this particular case was on for over 11 years. It's been back and forth, and fortunately last Wednesday, she was discharged and acquitted. So how significant is this particular judgment coming from the UK court after years of trial?
Yeah, what this means is that, you know, in Nigeria there are two courts, the court of law and the court of public opinion. In the court of law, you need evidence, hardcore evidence to convict. In the court of public opinion, you need sentiments and allegation to convict. And so what this means is that the court of public opinion might be right in the court of public opinion, but cannot be right in the court of law. Because in this case, there were evidence to show that Diezani actually lived a lavish lifestyle, you know, had so much money in terms of gifts, private jet arrangement, but there was no connection established between those monies and the award of contract or a contract.
Okay.
That she actually, it was those monies that influenced the award of those contracts, or that she had the influence to award those contracts. So there was no connection. That's why in law we say the action must tally with the intention, the actus reus and the mens rea. Unlike here, when, you know, we judge based on sentiment, over there, you know, they require hardcore evidence. That is why for them, prosecution starts from investigation. No matter here, once somebody lives, you know, a lavish lifestyle, the presumption is that you made money from public coffers. So that's all those monies. So we condemn that person in the court of public opinion. But that person must probably have made money
Before the appointment?
No. From that appointment.
Okay.
But you need to also establish the fact that those monies were made as a result of abuse of office.
Okay.
Also, one thing that works in our favor, I don't know how many people know this, that President Goodluck Jonathan testified in her defense that public officials here are liable to receive gifts from colleagues and associates, including Esther Code of Office. And then another thing was the fact that since public officers are not allowed to hold account, Nigerian ministers are not allowed to own account, foreign account, that they can spend money by proxy. You friends that, you know, are holding monies for them can give them this money when they travel abroad.
Okay.
So some of these monies might be money. This was the court's reasoning. Monies, you know, that his friends, you know, that he belonged to him back home, that he gave to his friends, and that they in turn gave to him, and cannot necessarily be said to be bribed.
Okay.
So those are the defense. That's what exonerated her. But not that, oh, they didn't find money with her, no.
Fine.
But that this money
were not tied
to the award of those contracts.
While
At some point,
she
she
was in
even said
office.
that, excuse me, she even said that they called her Madame Due Process, that she didn't have a way of influencing the award of contract. And the prosecution also didn't show that she actually influenced those awards.
Okay, I'm sorry, Abimola. Would it be right to say that there were evidential weaknesses then in this particular case?
Yeah, you can call it evidential weaknesses, correct. But you see, Nigerian politicians are very clever. Very, very clever. And so a lot of people would have learned from Liborous case. Mind you, Liborous case, they took out of the 173 count charge here, they just took about 4, and he was convicted on 2 over there. So when they are keeping funds, they don't take, unlike Ojus or Kalu, they don't take directly from the purse. And you remember the case of Stella Odua. I think from that matter, what happened was, if she wants, you will be the one to request, and then she approves for you. So the money didn't come directly to her. You know, so I have never seen a politician who would take money directly. They know, they are very smart. So they find a way to put monies in the hands of proxies. So you hear, Abibola is super rich. She's doing contract for government. And so the minister is traveling. She hires private jets.
For the minister?
For the minister. The private jet she has hired, it is not the minister that hired private jets.
It is not be in the minister's name. It would be in my name.
It is in her name.
Right.
And for you to now say the minister received the gifts of private jets from her, you need to establish that the contract that she was awarded, that the minister actually supervised the award of that contract. Meanwhile, the minister can, by words of mouth, say, look, that contract will go to her. So the tender board,
without documenting it,
tender board will meet, and then the chairman of the tender board will do the needful. That's the word, they do the needful. And then she gets the contract. There is no minister's signature, no imprimatur of the minister anywhere. It is solely the tender board's job, her financial, tenders, technical documentations, financial documentation, commercial, all are intact. But in the real sense, they were undercut, under dealing. So when you are investigating it, the law looks at the documents. Did the minister influence this award? Nobody has said anything. The minister was not part of the tender board. After the award of they took it to the ministerial tender board. The ministerial tender board met at Federal Executive Council.
It was approved.
And it was approved. And she got the contract. At the end of the day, the minister's court is buy one property.
Maybe it's another proxy. Okay.
So that's the way it works.
All right, Liborous, let's quickly look at the system. You've established the facts that, of course, this case, there was no evidence, of course, that linked Diezani to all of those allegations. But let's look at the jury system. The jury system was actually, it was the jury system that cleared her and acquitted her of all charges. Did that make any difference when you look at the judiciary, especially what we practice here and the jury system practiced in other parts of the world?
Before now, it was common for us to say, let us adopt the jury system. But with this case, a lot of people are now saying, I don't think we need to look at it very well again. But I still prefer that jury system where, where the facts will be dealt with by the everyday people. While the law will be dealt with by the judge, who is trained as a lawyer to deal with law. Because the judge cannot be dealing with facts and law at the same time.
The judge cannot be dealing with facts
and law at the same time. And that's our system here. The judge deals with both facts and law. So, but the jury system, the jury will look at the facts. The judge will tell them, just look at the fact of this case, leave out the law. So they look at the facts, the evidence gathered. Yes, they said that these gifts were proceeds of bribe. And if somebody is bribing you, there must be a benefit for that bribe. Otherwise, it will be a gift. And so that was where Goodluck Jonathan came in to testify that, yes, they can accept gifts. So they can accept gifts. So what is the end result of this gift? The moment the gift is to induce
the award of contract,
or abuse of office, then it becomes a bribe. That is now the position of the law. So once you've been able to establish that it was to get the benefit, then what does the law say when a benefit is derived from such gift? That's when the judge comes in to begin to look at what the law says and all of those. Omoto show me the law. But in this case, the jury looks at the fact and they said, well, from the facts that we have heard here, we have not been able to establish that truly all these gifts received were to influence, because
the award of contract,
nobody has influenced anything here. So another way is that you can't bribe all the jury. Here you can go to the corner and give something to somebody, to give to somebody, to give to somebody. But when you have the panel of 20 jury, you can't bribe all of them.
Absolutely.
So even though compromise can happen here and there. So I still think that system is a better system. It's more relaxed. But one big problem we would have here is who selects the jury. So if the influence of even appointing judges, people can influence appointment of judges, what's the guarantee that you can't appoint all your family members as members of the jury, or your party members to be members of the jury, and they'll be sympathetic to your cause? Because the way we argue law, it is only here that you hear a layman will tell a lawyer to keep quiet, let him teach him the law, you know. So it brings me back to Omotosho. Show me the law.
Okay.
You know, so that's just it. That's the quagmire we find ourselves. But I think somehow we need to find a way to tinker with our, you know, judicial system to create a balance. Also, because those people who are investigating these cases, can they be compromised? If they can be compromised, what's the guarantee that some, what do you call it, leaflets or some pages will not be missing in the file? And then you get to court and they say, you know, number 23 of the file is not there, or that the witness, in some cases, cannot be found, and the process has been stalled because the witness, you know, are not in court. So those are some of the challenges here. But by and large, what it means is that it is not enough for just to say, oh, this person is so rich, he has made so much money from government. The law does not look at stuffs like that.
Right.
The law goes deeper than that.
The law is not sentimental.
No, it's not. It's only here that the law is
sentimental.
Let me hold your thought, Jibola, before you take the next question. Let's quickly take a commercial break and we'll be right back.